whenever you guys are ready.
Now, if this was Pete,
Just
you
do
get one.
a 1, 2, 3.
Okay, I'll give you the countdown, right? 3.
Hafa Guam, it's Liz and Gina again, House to Home. And we have a guest here with us in our office. Her name is Georgette Bello Conception, and she's with Brooks Conception Law. And we're going to talk about probate. Take it away, Gina.
Well, you know, Georgette, part of the program is we've been trying to give out information that we're aware of, share information about probate from some of our customers who come to us. We end up dealing with a lot of families who perhaps didn't get the opportunity to take care of these details prior, and then they come to us to ask us probate questions, but we're not attorneys. We can't give out information. What we try to do is refer them to somebody they know that they could trust and get probate help. So one of the questions people ask us is, how long is this going to take, and do we really have to go through probate?
Well, it depends first of all, if you have a will, you still have to go through probate.
Yes.
And so probate is just a process by which the court administers a decedent's estate or assets. So if more likely than not, you will have to go through probate if you have real property, land that's in your name or the decedent's name, and the decedent didn't do anything while he or she was alive, like deed it to a relative or do some form of conveyance while they are alive. So in that instance, you would have to go to the court to probate real property.
So for instance, my mother passed away. She didn't leave a will. She didn't address who her home was going to. So under those circumstances, in order for us children to acquire title, it has to go through probate.
Correct. And so if your mother died without a will, then your mother would have died intestate, meaning no will. So then the Guam intestate succession laws would kick in. And so depending on whether your mother left a spouse and children, the law will determine how her assets would be divided amongst her heirs, which would be the surviving spouse and the children.
Some people seem to think that if you have a will, that's all you need.
No, like I said earlier, if you have a will, you still have to go through probate because only the court can administer the estate. So the good thing about having a will is that you tell the court and your family how you want your estate to be distributed.
Okay.
So you should probably do a will if you want to give one child all of your property, or you want to leave it to a spouse, or if you want to leave it to a charity, then you should do a will.
Okay. How long typically does it take to get probate done?
That's like the $1 million question.
It is. They always ask.
Yes, so it depends. A lot of times it depends on who the assigned judge is, because some judges are quicker than others in terms of moving the cases through. And then also it depends on the heirs. So if the heirs all agree as to how if there's no will, because if there's a will, then that's the law of the land, is you follow the will. But if there's no will, then it's intestate succession laws. But sometimes there are heirs who disagree with how things should be done.
Even in the presence of a will? Is that possible?
Yes, you can contest the will, and that happens sometimes. And so it really depends. That's my lawyer response. It depends.
Okay. So what's the worst? I mean, could they be looking at a year, 2 years? I mean,
no. If it's what I call a run-of-the-mill probate, it can be anywhere from 4 to 6 months, because you have to remember that when you open probate, after the administrator gets appointed, then you have to give creditors notice for 60 days to make a claim against the estate. So that takes a while. And then, and I think the probate code says you can't close the estate sooner than 120 days or 4 months from when you opened it. So it takes time, but it should be anywhere between 4 to 6 months. And so but again, it depends. But
sounds reasonable. Right. 4 to 6 months.
But the other thing I need to point out is once in a while, a person's real property will have a mortgage on it. So that's when the probate becomes a little more
time sensitive.
Yes, time sensitive, because then the administrator has to work with the bank. And so if one of the heirs are able to go and get the loan in their name, then there's no issue. But if they're not, then you have to, more than likely, you have to sell the property to satisfy the lien, and then if anything's left, then you distribute that amongst them.
I see.
Right. But that's, and also I want to point out that once in a while, if there's a mortgage on the property and the heirs don't do anything and the mortgage starts to go into arrears, then sometimes the bank as a creditor can go in and get appointed as administrator.
To liquidate the property.
Correct, but they have to go through the probate process. They can't just, go through the foreclosure.
Okay. And
So all family members have to be in agreement.
Not necessarily, because it's the administrator who will go to the court to ask the court's permission to do what needs to be done. And sometimes you can ask the court for guidance. But of course it helps, because lots of times the courts will want to know who agrees and who disagrees. But if you're going to disagree, then
It just messes up the whole process.
correct.
We've had a situation where one of the heirs had passed on, and the family members decided, well, they're not getting anything, it's just the remaining heirs. But the problem is, if they had a child from that particular heir, they have rights too,
Yes, yes, we do.
in terms of being included with the probate process.
Right, and I just want to make it clear that whatever I say today is just more informational.
Yes.
For informational purposes, I'm not
Absolutely.
giving legal
Yeah.
advice.
Yeah.
Although I do a lot of probate,
They'd have to call you.
or another, or any
Or
other
another
lawyer.
attorney.
Right.
That's
So
right.
just to make sure that their ducks are in a row and everything is covered. But probate should not be difficult. It shouldn't be a painstaking exercise, but it has to be done.
And so the real question then is, how much is this going to cost us? And that, that's always a concern from the families that we work
Because
with.
some of them don't have any monies, and they have to go through this process, and they have to figure out how is it going to work in terms of price.
Right. So again, it depends. The probate statute is it's the attorney fees and the court costs are all statutory. So it's kind of a sliding scale. So it depends on the value of the estate. But that's why I was saying that sometimes you have to go to the court and you have to ask to sell, because if nobody can pay all the probate costs, then that's the instance in which it will be appropriate to ask the court to sell the real property, pay off all of the end costs of administering the estate, and there's anything left, then that gets distributed amongst the heirs. That's the unfortunate part, especially when Tamaria leaves 10 children.
That's right.
And sometimes those 10 children, one or two have passed, and then it goes to their heirs. So by the time you get down to distribute to the second generation, then sometimes it's not a lot, but it has to be done. Otherwise, if you don't probate with the initial decedent, then it just keeps
adding up.
Yes, right. Yes.
And so in terms of the cost, if family members or a family member wants to do the probate, but they don't have any of the initial fees, is there an amount that has to be paid in order to get the probate started, or is it possible to start it without paying anything up front so that it could go through the motion of being ordered to be sold and they could use that money to pay the probate?
It would depend on the attorney's office, but
I see.
you do have to
Case
pay
by
the
case, yeah.
right, because there's a $300 filing fee that the court charges, and then you have to mail the notices to all the heirs by registered mail, and then on top of that, you have to then publish search notices, and so you're looking at anywhere from $1,000 to $1,500 just to start out.
Just
Just to get it
started.
started.
Right.
I see.
Well, thank you. You gave us a lot of wonderful information. So if any of you out there have a probate situation, give your attorney a call, or give Georgette a call and she'll give you some guidance. Thank you.